Okay, I'm back. We just finished the last stream about 30 minutes ago or so. If you missed that one, we went over the bankruptcy hearing in the Jan and Ron Owens case, where the court did dismiss their bankruptcy with a 2-year bar to refiling. You can go and check that out after this if you want, and you haven't seen it yet. But this is about Laura's attorney, David Gingras, who represented her in the case against Clayton Echard in family courts. David got himself into some hot water with the state bar based on his conduct in that case, and he has now gone to the Arizona Supreme Court over some of the issues in that case. He says the bar is trying to punish him for constitutionally protected free speech. The bar disagrees with that. We heard his side of that. It was either last week or the week before when we went over that with Patrick. Unfortunately, I don't have Patrick with me today, but I will go over the bar's response document here, and then maybe later on I'll have him come in and explain some of the legal stuff and the cases involved, because I'm not going to know much, if anything, about the cases that are cited here, so we might just, we'll stick to what we understand, and then we'll go from there. Okay, hold on, let me pull this up. I might need to change my mic settings. It's been a little quiet. Oh, it's because I have the wrong mic on there. There we go. Does that sound better? It should sound better now. This is defaulting to my webcam mic. Okay. This is from the JFC subreddit, so if you guys want to pull up these documents at any time, you can always go there and click the links that they posted. So, I blame your mom. You blame my mom. What did my mom do? Alright. The State Bar of Arizona, by undersigned Bar Counsel, submits this response to the petition for special action. Based on the arguments set forth below, this court should decline jurisdiction over this special action because, on balance, the factors for declining jurisdiction set forth in Rule 12 outweigh the factors for accepting jurisdiction. The petition raises primarily fact-specific issues decided in interlocutory rulings that are not and could not be case dispositive. For example, some allegations of misconduct have not yet been adjudicated. And petitioner David Gingras has an equally plain, speedy, and adequate remedy by appeal following a hearing on the merits of the allegations not yet addressed by presiding disciplinary judge Lisa Vandenberg. And remember, he also asked the state Supreme Court to assign a new judge if they, ruled again, if they ruled in his favor and then kicked this back. He wants a new PDJ. One second. Turn the volume up. Okay, I turned it up, but I don't know if it's any better now. Let's see if I can pull this forward. Okay, how's that? You have to tell me if it's working before I don't want to read anymore until I know if it's working. The problem is that some of you guys are behind, and so you're like, I can't hear you, but maybe now you can hear me, but yeah, okay. Somebody says better. Is it good enough? Okay, thank you. Crab, Mariner, and Brummy say it's good. All right, we're good then. The petition raises primarily fact-specific issues decided in interlocutory rulings that are not and could not be case dispositive. We went through that. Okay, yeah, okay. The State Bar of Arizona filed a one-count complaint against Mr. Gingras on February 17th, which included multiple allegations of misconduct, violation of a court order, efforts to preclude a potential witness from testifying at a court hearing, making disparaging comments about a judge and members of the public, meritless claims, false information in an affidavit, non-meritorious appeal. So there's a lot there that they were looking at, not just his comments about Judge Mata. However, he's trying to say that basically their whole case should be thrown out on anti-SLAPP grounds because of the stuff he said about Mata. Remember, his conduct towards Mata during all these proceedings has been really strange. He tried to, I guess, get in touch with her dad, tried to contact them both, tried to send mail to, I believe, her dad's house. If I'm incorrect about that, it's been a while now, so, correct me, but I'm pretty sure that that happened. And her dad was just like, this guy is crazy, basically, in his filings. Like, this doesn't make any sense. This is goofy. He tried to notice me for a deposition that should have happened today, and like that there was a lot of goofy stuff going on there, and it was creepy. Like he tried to send somebody to the courthouse to have Judge Amata served, did not want to serve her through her representative, so there was just a lot going on there. Okay. Okay, enough. Still low. I mean, I can try to turn it up a little bit more, but I don't want it to be too loud. Is the thing. It's really weird though, because it's all the way up to 188. Okay. Maybe if I look at the setting one more time. Default, sure. Okay. How about that? I can see that it's kind of low on the thing here. I don't want to shout is the problem. And if I start shouting, then it looks normal. But let me see if I move this in. Okay. Let's point that away. I'm watching through the TV, and you are great sounding. Well, okay. Everybody's got a different experience here today, I suppose. But we're just going to have to move along with what we got right now. Okay. Mr. Gingras filed an answer on February 17th. Based on concerns expressed by the PDJ, an amended complaint was filed on February 25th. Mr. Gingras filed a respondent's amended answer on March 6th. On March 9th, the State Bar filed a motion for partial judgment on the pleadings. Mr. Gingras filed a response. Okay. We don't really need to read the back and forth about all that happened. I just want to get to the part where it's like, this is what was ruled. Okay. On April 14th, he filed a motion to dismiss and alternatively a motion for summary judgment based on Arizona anti-SLAPP statutes. The State Bar filed a motion to strike that motion to dismiss. The PDJ entered an order directing the parties to simultaneously submit briefs addressing whether the court's supremacy clause precludes this anti-SLAPP legislation's application in discipline proceedings. Okay. They did those. On June 22nd, the PDJ entered an order denying Mr. Gingras' motion to dismiss based on Mr. Gingras' failure to demonstrate that the anti-SLAPP statute does not unduly hamper the court's authority over the practice of law in Arizona, noting that in the absence of such a showing, she is unable to determine how to apply the statute in a manner consistent with the court's rules regarding attorney discipline. Okay. On July 22nd, that was just a couple weeks ago, Mr. Gingras filed his petition for special action appellate with the Supreme Court here, which is what we read a couple weeks ago. This is the State Bar's response to that petition. Okay. 1 second, guys. All right. Mr. Gingras, through counsel, and his counsel is his friend Mark Randazza, right, identified 4 issues in his petition for special action. 1, must attorneys surrender their First Amendment and Arizona free speech rights by becoming members of the bar? 2, do Arizona attorneys retain the same First Amendment and Arizona constitutional protections as other citizens? And if so, did the State Bar establish that petitioner's speech falls within a recognized exception permitting discipline? 3, did the presiding disciplinary judge err by granting judgment on the pleadings when the material facts were disputed and by applying an erroneous legal conclusion that the First Amendment and Arizona constitutional protections for speech do not apply to lawyers? And 4, does Arizona's newly expanded anti-SLAPP law apply in attorney discipline proceedings? And if so, does it unduly hamper this court's authority to regulate the practice of law in Arizona and therefore violate separation of powers principles? The State Bar contends that the issues identified by Mr. Gingras do not fairly and accurately identify the issues this case actually presents. Okay, that makes sense to me. Because he seems to be making arguments and missing the point of, like, his statements were not truthful. First of all, he made sweeping accusations as fact when he didn't have anything, any evidence to back up that conclusion. So that was kind of a problem. Mr. Gingras' first and second issues are significantly overbroad, and even if answered, would not resolve any issue in this case. And Mr. Gingras' third issue lacks specificity. Right. The case actually presents the following issues. 1, should the court accept jurisdiction to review the PDJ's interlocutory ruling? granting partial judgment on the pleadings, where a reversal would not result in judgment in Mr. Gingras' favor, but a remand for additional fact-finding. And 2, should the court accept jurisdiction to review the PDJ's interlocutory ruling denying Mr. Gingras' motion to dismiss based on Arizona's anti-SLAPP statute. If this court accepts special action jurisdiction, the issues then become 1, whether the PDJ properly granted, in part, the State Bar's motion for a partial judgment on the pleadings, finding that Mr. Gingras violated, and there's the rules there that they put out there, by making disparaging comments about Maricopa County Superior Court Judge Mata, and 2, whether the PDJ properly concluded that Arizona's anti-SLAPP statute does not apply in lawyer discipline proceedings, absent evidence that the statute does not interfere with this court's constitutional authority to regulate the practice of law. So his comments, they weren't just on his personal blog, too. You got to remember, like, he did this in a filing while Judge Mata was still the judge on the case, and he was trying to get a change of judge, but he, put that whole "look at me, daddy" comment in his professional work, which he submitted to the court. So it wasn't just the offhanded comments he put on the blog and elsewhere. It was also his actual work as an attorney, where he disparaged the judge presiding over the case. So that was crazy. One sec. All right. Additional facts not included in the petition. I don't think he would ever leave anything out. I mean, come on. The State Bar alleged in its amended complaint that Mr. Gingras made public disparaging comments about Judge Mata. The Bar alleged that Mr. Gingras made disparaging comments in a notice of change of judge for cause, internet postings, and a podcast he posted on the internet. Which one, dude? Mr. Gingras' petition for special action inaccurately asserted that the State Bar acknowledged factual disputes existed, but argued they were legally irrelevant because constitutional free speech protections are not a valid defense in attorney disciplinary proceedings. Okay. The State Bar acknowledged that Mr. Gingras did not admit every allegation in the complaint and argued that lawyers have limited First Amendment rights when they make statements while engaged in the practice of law. Clearly, lawyers retain some free speech rights that may not be adjudicated in lawyer discipline proceedings. Okay. And then they cite a case here that says, or cite a rule here that says permissible extrajudicial statements regarding general facts about a case and statements required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Okay. They put a footnote here. In denying Mr. Gingras' motion to dismiss, the PDJ stated, Respondent Gingras has failed to demonstrate that the statute does not unduly hamper the court's exercise of its constitutional authority regarding the practice of law in Arizona. Yeah. Okay. South Florida Thrifter, thank you for the 10 jewels. I appreciate that. Unprofessional conduct occurring while engaged in the practice of law may result in the imposition of disciplinary sanctions. Okay. Ethical Rule 8.2a says, a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory officer, or public legal officer, or of a candidate for election or appointment to judicial or legal office. I would say that he definitely did make a statement with reckless disregard as to its truth. In his, legal filings, he basically said the judge made the ruling that she did not based on the merits of the case, but to impress her father. He stated as a fact in multiple avenues that the judge, looked up information on, impermissibly looked up information on social media or the internet and put that in her ruling. He doesn't actually have any proof or know where she got that information. It was obviously a misstatement. Because that was not actually said, that Planned Parenthood is closed on Sundays was not actually said during the testimony. However, it was not really that material to the case or the ruling at all. And again, he was reckless, I believe, in my opinion, when he said that as a statement of fact, when he doesn't know where she got that information, where it came from. Maybe it's based on her experience with Planned Parenthood or among other things. You can't state something like that as a fact if you don't really know. You don't have any evidence to back that up. Steph and Callie, thank you for the 10 joules. Appreciate that. And Sally Turner, 8996. Thank you for the 1,000 joules. Awesome. All right, let's see. Rule 41 requires lawyers to maintain the respect due to courts of justice and judicial officers, and to avoid engaging in unprofessional conduct. The oath of admission to the bar provides, in pertinent part, that lawyers will treat the courts of justice and judicial officers with respect. 2, will avoid engaging in unprofessional conduct. Oh, that's a problem. 3, will not advance any fact prejudicial to the honor or reputation of a party or witness unless required by their duties to their client or the tribunal. And 4, will at all times faithfully and diligently adhere to the rules of professional responsibility and a lawyer's creed of professionalism of the State Bar of Arizona. The creed requires lawyers to conduct themselves in accordance with the Code of Professionalism when dealing with clients, opposing parties, opposing counsel, tribunals, and the general public. And I would say just in general, like, the way he treated Greg Woodnick throughout that case and since then is unacceptable, but I don't know how that falls in with their rules and what they're considering there. But Greg Woodnick, like, he's disparaged Greg Woodnick all over the place, accused him of lying and all kinds of things, which it doesn't even make sense. Okay. Lawyers must be courteous and civil, both in oral and written communication. In negotiations, depositions, and other proceedings, they are to conduct themselves with dignity and not be rude or disrespectful. And remember, the lawyer for Laura during the depositions was Corey Keith. So David, I don't believe David was her lawyer for her deposition. I think Corey was her lawyer for her deposition, but I could be wrong about that. But I know that Corey was the lawyer for Laura during Clayton's deposition because Corey was the one that questioned him. So. And I know that because David posted clips of it on his YouTube channel, and so did Laura, which is really strange, a really strange thing to do. So, Seamus931, thank you for the $5. Completely off topic. Your skin is beautiful, Lauren, like a newborn baby. Thank you. Appreciate that. Okay. Okay, so the bar says the court should decline jurisdiction of the special action. Right. This court has special action jurisdiction in state bar disciplinary proceedings. The decision to accept appellate special action jurisdiction, however, is discretionary. Okay, so I guess they don't have to, right? They say in the footnote here, the state bar's arguments in this response are not presented in the same order or format that Mr. Gingras presented his arguments. The state bar believes the issues and arguments are more limited than those identified by Mr. Gingras. Okay, well, that doesn't surprise me. Right. Rules 12b and c identify several factors this court should consider in determining whether to accept or decline appellate special action jurisdiction. Jurisdiction for this appellate special action should be declined based on the factors set forth in Rule 12, because the factors that support declining jurisdiction outweigh the factors that support accepting jurisdiction. Okay. Factors that support special action jurisdiction, they say 12b1, the special action was not designated for review under Rule 13. Mr. Gingras does not assert any legal or evidentiary privilege or immunity from suit. Okay. The applicability, well, I can't talk. The applicability of the First Amendment in Article 2, Section 6 of the Arizona Constitution to lawyers engaged in the practice of law is not a matter of first impression. Okay. This is the note in they're citing the Riley case here. It says a lawyer may be disciplined if his public comments threaten a significant state interest. Okay. The good standing of the judicial system is such a significant interest. Generally, a lawyer may accurately criticize a sitting judge, but may not impugn the integrity of the judicial system or raise the questions or question the decisions of the judge. Okay. Alright. I'm just skimming through those case citations because I think we got the point. The applicability of Arizona's anti-SLAPP statute in lawyer discipline cases is an issue of first impression, but it is one that can be resolved based on the specific facts in this case. Right. Rule 12b4, although the applicability of the First Amendment, Article 2, Section 6 of the Constitution, Arizona Constitution, and Arizona's anti-SLAPP statute, as they pertain to lawyers engaged in the practice of law, are issues of statewide importance, this case raises as-applied challenges to certain ethical rules that are specific to the facts of this case. The issues this case presents, therefore, are not issues of statewide importance. Okay. And we're still going through the rules here that they say supports special action jurisdiction, and then I guess they'll get to the ones that don't. Right. Constitutional limitations imposed on lawyers engaged in the practice of law do not raise issues that tend to evade review or become moot before an appeal. The case does not involve the welfare of children, not real children anyways, fake ones, I guess. Okay. The court's special action resolution of constitutional restrictions on lawyer speech will not materially advance the efficient management of this case. Okay. The PDJ's granting in part of the State Bar's motion for partial judgment on the pleadings did not resolve all allegations in the amended complaint. Therefore, the remainder of the allegations of misconduct, for example, violation of a court order and non-meritorious claims made on appeal, will be addressed by a hearing panel regardless of this court's decision whether to accept or decline special action jurisdiction. Following a hearing on the merits, one or both parties may appeal. This special action does not raise an issue concerning the PDJ's decision that cannot be justified under any rule of law. As noted below, the PDJ appropriately granted in part the State Bar's motion for partial judgment on the pleadings and denied Mr. Gingras' motion to dismiss. Right. Factors that support declining special action jurisdiction. Okay. Mr. Gingras unreasonably delayed seeking special action review of the PDJ's granting of the State Bar's motion for partial judgment on the pleadings. The PDJ entered an order granting in part the State Bar's motion for judgment on the pleadings on April 14th. He did not file a petition for special action review until July 22nd, so that's like 3 months, a little over 3 months later. Had Mr. Gingras promptly sought and obtained special action relief regarding that issue, the parties could have timely undertaken discovery into his disparaging comments about Judge Julie Mata. Okay. Rule 12c1, Mr. Gingras argues that he raised material factual disputes that should have precluded judgment as a matter of law. Special action jurisdiction, however, is not appropriate to resolve disputed facts. Okay. If this court were to accept jurisdiction based on disputed facts, this court would simply result in a remand for further factual development, not in the resolution of the constitutional issues that Mr. Gingras claims make this matter an issue of statewide importance. Okay. The PDJ resolved the constitutional and anti-SLAPP issues under Rule 12c, which are incorporated into the lawyer discipline procedural rules by Rules 47d and 48b. That fact supports declining special action jurisdiction. To the extent that Mr. Gingras argues that lawyers have the same First Amendment protections as members of the public, that issue has been clearly resolved by settled law. See above for cases addressing limitations on lawyers' First Amendment rights. I mean, anybody can be, punished or disciplined within the scope of their job for, bad-mouthing the boss online or saying things that aren't true, that are reckless about the company. Like, anybody would be, subject to discipline for that. So for him to think that lawyers should be immune to any sort of consequences for their actions, especially if they say false or misleading things that undermine public trust in the judicial system, that's just kind of ridiculous to me. Of course there should be consequences for that. Okay. Don32898, thank you for the 10 joules. I appreciate that. And Angela Sullivan, thank you for the 600 joules. That's awesome. Thanks so much. All right. The issues raised by Mr. Gingras are equally appropriate to address on appeal. Mr. Gingras claims that partial judgment on the pleadings was improper because he denied various allegations in the complaint. Because the PDJ found sufficient factual grounds based solely on the pleadings to conclude that Mr. Gingras engaged in misconduct, the sufficiency of the admitted allegations is a matter more appropriate for appeal. Okay. This court's resolution of the issues raised by Mr. Gingras will not materially advance the efficient management of this case. As noted above, this court's resolution of the issues raised will not resolve all allegations of misconduct, thus necessitating a substantive hearing before a hearing panel to address the remaining allegations of misconduct. So basically, this won't solve everything, In addition to the factors set forth in Rule 12c, if this court determines there are factual disputes that preclude it from determining whether the PDJ appropriately granted, in part, the State Bar's motion for partial judgment on the pleadings, the appropriate remedy is to remand the matter to the PDJ. Okay. If this court declines special action jurisdiction, Mr. Gingras may appeal the PDJ's ruling on the constitutional issues, the applicability of the anti-SLAPP statute to lawyer discipline proceedings, and the State Bar's motion for partial judgment on the pleadings following a hearing on the merits of the remaining allegations of misconduct. Okay. Mr. Gingras could raise all issues on appeal, both those the PDJ has already addressed and those that may arise during a hearing on the merits. It is more efficient in this case for this court to decline special action jurisdiction than to bifurcate the issues for this court's consideration, once in this special action and thereafter on appeal. Okay. As noted in Rule 12b, this court is not required to accept special action jurisdiction simply because one or more factors support accepting jurisdiction, especially when factors that support declining jurisdiction outweigh those factors in support of accepting jurisdiction. Mr. Gingras noted in his petition that this court has held that interlocutory review is especially appropriate when a case presents a substantial First Amendment issue for which a party has a case-dispositive First Amendment defense. As set forth below, Mr. Gingras does not have a case-dispositive First Amendment defense to the allegations in the State Bar's complaint. He's also incorrect in his assertion that if this court declines jurisdiction, he will be required to litigate the remainder of the case under a fundamentally incorrect legal standard that is inconsistent with controlling state and federal constitutional precedent. But how is that so? I mean, they're saying he's incorrect, but how does he figure? I don't remember that. As noted above, lawyers' First Amendment rights may lawfully be limited while engaged in the practice of law. Based on the foregoing analysis, this court should decline special action jurisdiction. Okay. One sec. All right. The PDJ properly granted in part the motion for partial judgment on the pleadings, finding that Mr. Gingras violated ethical rules by making disparaging comments about Judge Mata. Okay. Mr. Gingras admitted numerous allegations in the State Bar's complaint, partially admitted other allegations, and denied still others. The denied allegations were unnecessary to establish a violation of the rules. Okay. Mr. Gingras asserts that the State Bar's primary position is that attorneys surrender their First Amendment rights upon admission to the bar. The State Bar has never taken such a broad position. The state does, however, assert that bar members' free speech rights are limited when they are engaged in the practice of law. For example, lawyers' free speech rights are limited when, as here, they make disparaging comments about the judge during the pendency of a case in which they are involved, which is what he did. Even in his pleading, or his filing where he asked for a change of judge and mocked the current presiding judge of the case and said the "look at me daddy" thing, and basically that she was a dumb bimbo who was trying to impress Clayton is essentially what he said. He didn't use the word bimbo, but it was almost as bad. Okay. Mr. Gingras incorrectly asserts in his petition that the PDJ granted the State Bar's motion for partial judgment because his First Amendment and constitutional defenses failed as a matter of law, because attorneys do not enjoy the same constitutional protection for speech as other citizens. The PDJ rather found that Mr. Gingras had not asserted the language he used in disparaging Judge Mata was objectively and reasonably necessary to advance his client's matter. The language that he used was definitely not necessary. He could have done that professionally. He could have made his argument professionally. Okay. She also noted that the oath of admission to the bar and the lawyer's creed of professionalism require lawyers to, among other things, treat judicial officers with respect, avoid engaging in unprofessional conduct, be courteous and civil, both in oral and written communication, conduct themselves with dignity, and not be rude or disrespectful. Mr. Gingras generally argues that the rules of professional conduct must yield in all circumstances to the First Amendment's free speech rights. That is not an accurate summary of the current state of the law. The First Amendment, like every other amendment, is not absolute. Okay. And they cite a case here in Sawyer that says lawyers in pending cases are subject to ethical restrictions on speech to which an ordinary citizen would not be. Lawyers' disparaging comments about judges, particularly when they are involved in proceedings before the judge, may result in the public losing confidence in the impartiality of the courts. Right. And then they show matter of Terry. Here it says unwarranted public suggestion by an attorney that a judicial officer is motivated by criminal purposes and considerations does nothing but weaken and erode the public's confidence in an impartial adjudicatory process. And they cite some more cases here to make their point, but I'm not going to go through all those. The U.S. Supreme Court has held that a state may adopt lawyer conduct regulations that may limit lawyers' First Amendment rights. Okay. In Gentile, the U.S. Supreme Court found Nevada's trial publicity ethical rule void for vagueness, as interpreted by the Nevada Supreme Court. In Mr. Gingras' case, the state bar did not allege that Mr. Gingras violated ER 3.6, Arizona's trial publicity ethical rule. Gentile nevertheless reflects that lawyers' First Amendment rights may be limited while engaged in the practice of law. Okay. The Arizona Court of Appeals has addressed the limitations on lawyers' free speech rights, stating resort to epithets or personal abuse is not in any proper sense communication of information or opinion safeguarded by the Constitution. Right. This court has also addressed limitations on free speech in the context of the practice of law. Okay. And then they have a block quote from Riley there, but I'm going to skip that. Mr. Gingras' comments about Judge Mata outside the courtroom are properly subject to Supreme Court Rule 41 and the rules of professional conduct because they were made while he was counsel of record in the case, which was still pending. In one instance, one of Mr. Gingras' disparaging comments was included in a document he filed with the court on his client's behalf, and that would be the "Look at Me, Daddy" document. Okay? Mr. Gingras' disrespectful and disparaging comments about Judge Mata were unnecessary. He simply could have commented on the proceeding without editorializing about Judge Mata or asserting as fact matters for which he had no or limited information. Right. The PDJ noted in her April 14th, oops, my bad. The PDJ noted in her April 14th order that it was not necessary for Mr. Gingras to disparage Judge Mata to competently and diligently represent his client, right? So it was totally unnecessary for him to talk the way that he did, to write the way that he did. I guess he thought that he was being impressive or whatever, but it was actually just kind of embarrassing. All right. Mr. Gingras claims he did not violate the ethical rules because he was diligently representing his client. That belief, however, is without merit. This court has stated, respondent says that he would not have behaved as he did if the judge had acted properly. Regardless of respondent's belief that his actions were necessary to protect the client's interests, his behavior was inexcusable. Right. And then they're citing some cases here. Right. The State Bar is not required to prove that Mr. Gingras knew that his comments about Judge Mata were false. Rather, the Bar need only prove that he acted with reckless disregard for the truth or falsity of his statements. The inquiry to be made is whether Mr. Gingras' factual basis for making the comments was objectively reasonable. Okay. And then they cite a case here that says an objective standard is used to determine if demeaning language constitutes unprofessional conduct. Mr. Gingras claims the PDJ's granting in part of the motion for partial judgment on the pleadings was inappropriate because he denied in his answer that he made any statement that was false or made any statement with reckless disregard for the truth. To sustain an allegation that Mr. Gingras violated ER 8.2, the State Bar must prove that Mr. Gingras knowingly made false statements or made statements with reckless disregard. Okay. ER 4.4a and ER 8.4d and Rules 41b3 and 7 do not require proof that Mr. Gingras made false statements or made statements with reckless disregard for the truth. Huh. Okay, I didn't know that. Do not require proof that, okay. Therefore, the PDJ's finding that he violated these rules may nevertheless be affirmed. Okay. The cases cited by Mr. Gingras in support of his argument that the U.S. Supreme Court has repeatedly rejected limitations on a lawyer's First Amendment right pertain to a bar applicant's refusal to answer a question whether she had ever been a member of the Communist Party or any organization that advocates overthrow of the United States government by force or violence, B, commercial speech, and C, a lawyer's right to defend his/her client during the pendency of litigation when comments have been made by an opposing party. Okay. In Olin, cited by Mr. Gingras, the bar court found that Attorney Olin engaged in misconduct by making statements with reckless disregard for the truth, while disrespecting judges by making derogatory and false statements, which were not protected speech. The bar court stated, although attorneys are entitled to the protection of the First Amendment, even as participants in the administration of justice, disparaging statements amounting to an attack on the honesty, motivation, integrity, or competence of a judge may subject an attorney to discipline. Okay. The Bar Court in Olin stated that other courts had noted that reasonable speech restrictions may be imposed under certain circumstances upon attorneys given their special status as officers of the court. That court also stated statements characterized as rhetorical hyperbole and statements of opinion that are incapable of being proven as true or false are not sanctionable unless such statements could reasonably be understood as declaring or implying actual facts which themselves are false. Like maybe saying that the judge ruled against your client strictly because she wanted to impress her daddy. That might be one of those situations. I don't know. Although the Bar Court stated that truth is an absolute defense to any statement made by an attorney that impugns the honesty or integrity of a judge, at least some of Mr. Gingras' comments were not truthful. And there he has a problem. Also warranting a finding that Mr. Gingras engaged in unethical conduct is the demeaning and disparaging manner in which he asserted that Judge Mata acted inappropriately. For example, Mr. Gingras included the following on a social media post. Oh God, they're going to quote him directly. That sucks. All right, one sec. So this is directly from one of David's blogs or tweets or something, and they're quoting him here. It says, "Annoyingly, but not surprisingly, Judge Mata screwed up the form of final judgment. It doesn't contain stuff required by the rules. Shocker. We could ask her to fix this, but that would be a waste of time." Dude. Oh, what are you doing? Okay. The last sentence of that post implies, without any evidence, that Judge Mata would refuse to correct an incorrect rule citation if it was brought to her attention. I mean, yeah, that is the implication. The implication is disparaging insofar as it presupposes that she would violate the Code of Judicial Conduct by refusing to correct an incorrect citation in a judgment which had been brought to her attention. Mr. Gingras also alleged that Judge Mata committed a crime. Mr. Gingras failed to thoroughly research whether an Arizona Superior Court judge may modify the terms of a DVRO issued in California. He further posted on the internet that Google is not a valid legal source of evidence unless your case is assigned to Judge Mata. Dude. I forgot how bad some of this stuff was. I know it got a lot worse than this, but this is the stuff related to their case, so. That statement implied actual facts that were without a factual basis or amounted to an opinion that could be proven false. Finally, Mr. Gingras stated the following during a podcast. Oh no. Not the podcast. If Judge Mata was a person who cared about the rules, she would have sanctioned opposing counsel. So they're talking about Woodnick here, right? That's not a secret, but they've took out his name. She would have sanctioned Woodnick for making a false statement about the law. Okay, and then the bar says, that statement either implied that Judge Mata did not care about court rules or expressed an opinion that could be proven false. Mr. Gingras' comments stated and implied actual but false facts about Judge Mata. Just as in Olin, Mr. Gingras' statements were nothing more than mere conjecture. In Olin, the bar court found that Attorney Olin violated his duty to maintain the respect due to the courts of justice and judicial officers in violation of Section 6068B. I think they have in their appendices his post they've used here. Let me go to Reddit and see. There's Appendix 1. I just want to roll through and look at this real quick. State bar's motion to strike. Okay, no, these are just cases they're citing, I think. Let me see Appendix 2. Or maybe it's the bottom of the document we were just reading, I'm not sure. This is Gajic. This is all one document, isn't it? Yeah, I don't think this is what I'm looking for. That's okay, though. Maybe they're at the bottom of this page, or maybe we just don't have them yet, so. Special action certificate, appendix. Yeah. Okay. We'll keep going. One sec. Gemma L says, I wonder what the court thinks about his client getting charged with all the fake pregnancies in Arizona. Lawyers do have to do their best to ensure the paternity filing was in good faith. I don't think he did his best to ensure that it was in good faith, but he would argue differently. So I don't know. There's a lot of things that the bar has brought against him, and some of it relates to like not correcting false information, etc. So, all right. Okay. PDJ properly denied Mr. Gingras' motion to dismiss based on Arizona's anti-SLAPP statute. Arizona's anti-SLAPP law allows a person other than a state actor or an intervener to file a motion to dismiss a legal action if it was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. Lawyers retain First Amendment rights, but their free speech rights are limited while engaged in the practice of law. For example, lawyers engaged in the practice of law do not always enjoy the same rights that non-lawyers enjoy. Just skipping through the case citations here. Assuming that the anti-SLAPP statute applies in lawyer discipline cases, Mr. Gingras nevertheless may not rely on it for dismissal of the state bar's complaint, because lawyers do not have a constitutional right to disparage judges in pending cases in which they are involved. The statute requires the lawful exercise of the right of petition, the right of speech, ... Okay. Furthermore, Mr. Gingras has not established prima facie proof that the state bar's complaint was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. The court must determine whether the anti-SLAPP statute applies to lawyer discipline cases in which the state bar alleges that a lawyer has made disparaging comments about a judge in a case in which the lawyer is involved. This raises an issue, as noted by Mr. Gingras, whether the state legislature's adoption of the anti-SLAPP statute invades the province of this court's supervision of the practice of law. Although the two branches of government have generally distinct purposes, even if the anti-SLAPP statute were to be found to be exclusively procedural, this court will enforce it if it is reasonable and workable and does not conflict with court rules. Okay. This court must also determine that the anti-SLAPP statute provides substantive rights to lawyers involved in lawyer discipline proceedings. This court may defer to legislation regarding procedural matters that promote substantive goals of public policy. The state's inclusion of language authorizing the recovery of costs and reasonable attorney's fees may also be deemed to create a substantive right. Furthermore, the statute may create a substantive right because it provides a procedure for citizens to promptly prevent forced litigation of a non-meritorious case, which could result in the expenditure of time and money. Okay. When determining whether a statute is procedural or substantive, the Supreme Court looks at the true function of the statute at issue rather than relying on labels. At least one court has found that an anti-SLAPP statute was a hybrid procedural/substantive law. The public policy underlying the anti-SLAPP statute is simple, ensuring that citizens and residents may assert their constitutional rights without the fear of retaliation through the courts. The question becomes whether the Arizona anti-SLAPP statute usurps this court's rulemaking authority and violates the separation of powers doctrine if it were to be applied in lawyer discipline cases. Okay. There is a lack of consensus among courts whether anti-SLAPP laws are primarily procedural, substantive, or a combination of both. While courts have split in determining whether anti-SLAPP laws primarily provide substantive rights or procedural rights, all have at least some procedural elements establishing an expedited procedure to resolve whether a lawsuit was filed primarily in an effort to quash a defendant's constitutional rights. The Second Circuit Court of Appeals has found that a state's anti-SLAPP statute provided substantive protections. The 10th Circuit has found that a state's anti-SLAPP statute was procedural and therefore conflicted with the federal rules of civil procedure, and other circuits in the D.C. Court of Appeals have found that anti-SLAPP statutes include substantive and/or procedural rights, depending on the law under review. There's also a lack of consensus among state courts whether anti-SLAPP laws primarily established substantive or procedural rights. Kentucky and Maine have held that anti-SLAPP statutes provide procedural rights, whereas Connecticut and Oklahoma have held that their state's anti-SLAPP statute created substantive rights. Georgia, on the other hand, has determined that its anti-SLAPP law is both procedural and substantive in nature. Whether this court determines that Arizona's anti-SLAPP statute provides substantive or procedural rights, or a combination of substantive and procedural rights, application of it to lawyer discipline proceedings would be inappropriate because it invades the court's authority over the practice of law, and application of the statute may be prejudicial to this court's administration of the practice of law and enforcement of the rules of professional conduct. Okay. It says due to possible delay and the duplication of hearings. Okay. Even if this court were to conclude that Arizona's anti-SLAPP statute applies in lawyer discipline cases, the statute would apply only when lawyers can prove they were lawfully exercising their constitutional rights, and the state bar is substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. Okay. So he has to prove that they strictly did this to prevent him from exercising his free speech rights as well. Or no, he doesn't have to prove that, but I guess they have to show that they did this for reasons other than that, or that that wasn't their law, their strict reasoning. One second. As noted above, this court has held that lawyers have limited free speech rights while engaged in the practice of law. Mr. Gingras' disparaging comments about Judge Mata were made in the context of his representation of a client during the pendency of her case. Mr. Gingras' comments about Judge Mata were not made during the lawful exercise of free speech rights. Determining whether a lawyer has lawfully exercised his/her free speech rights is a matter that can and should be made by the PDJ, subject to appeal at the conclusion of a hearing on the merits of the state bar's complaint. Mr. Gingras asserts that the PDJ assumed the judiciary possesses inherent authority to discipline attorneys for constitutionally protected speech. The state bar does not believe the PDJ made that assumption. In Mr. Gingras' case, his comments were not constitutionally protected speech, as noted above. This court has imposed discipline on lawyers who have made disparaging comments about judges. All right. Based on the criteria for accepting and declining appellate special action jurisdiction, this court should decline special action jurisdiction. Okay, the factors that support declining outweigh the factors that support. In this case, special action review is unnecessary because Mr. Gingras has an equally plain, speedy, and adequate remedy by means of appeal. Okay. If this court accepts appellate special action jurisdiction, it should find that lawyers' First Amendment rights are restricted while they are engaged in the practice of law in Arizona, and that the PDJ correctly found that Mr. Gingras violated, and then they list the rules there, by making disparaging remarks about Judge Mata during his representation of a client. Membership in the bar is a privilege burdened with conditions. Yeah, that sounds about right. One of the conditions imposed on lawyers is a limitation on their First Amendment rights while engaged in the practice of law. The state bar has not attempted to regulate the content of Mr. Gingras' speech based on the rules of the Supreme Court. The bar is simply attempting to enforce the lawyer conduct rules. This court's ethical rules prohibit making false statements or statements made with reckless disregard as to their truthfulness or falsity or otherwise acting unprofessionally. So he's said multiple times throughout this that what he said was true, so that's a total defense. You know, like what he said was true, so they can, or that he was going to depose Judge Mata and her father and all this stuff and get to the bottom of it. None of that happened. So, I mean, he never did show that what he was saying was true, and it does appear that he made those statements. Even if he had made those statements and then did discovery into all that, he made the statements without any evidence. He made the statements without looking into it. So when he made those statements, they were with a reckless disregard as to the truthfulness, in my view. Okay? Justice for Patrick. What happened to Patrick? Okay. Arizona has a compelling interest in how lawyers engage in the practice of law and may adopt rules to protect valid state interests. Arizona has a valid state interest in ensuring that its residents have faith that the judiciary is objective, neutral, and fair. Mr. Gingras argues that he had a First Amendment right to make disparaging comments about Judge Mata, and that the truthfulness of his comments is an absolute defense to the imposition of discipline. Okay, but he never showed that he was telling the truth. There's nothing to support what he said. He has overlooked case law from Arizona and throughout the United States that stand for the proposition that state Supreme Courts may limit a lawyer's false statements and statements made with reckless disregard for their truthfulness or falsity or otherwise acting unprofessionally. Mr. Gingras' disparaging comments about Judge Mata were not required to diligently represent his client. He could have simply noted any provable errors without including any disparaging commentary. In addition, he could have utilized other means of redress, filing a motion to reconsider, a special action, or an appeal. Finding that lawyers have limited First Amendment rights while engaged in the practice of law will not prevent lawyers from addressing a judge's alleged misconduct. The State Bar agrees with Mr. Gingras that any disciplinary rule that seeks to punish constitutionally protected speech is simply not a valid or enforceable rule. He fails to note, however, that lawyers' First Amendment rights may be constitutionally limited when their comments are false or made with reckless disregard for the truthfulness or falsity or otherwise intentionally disparaging. Finally, if this court remands this matter to the PDJ for further proceedings, there is no evidence that the PDJ would be biased against Mr. Gingras, so referral to another judge is unwarranted. Because he did say he wanted a different judge if it was kicked back. So, furthermore, nothing in this court's lawyer discipline procedural rules requires a matter to be assigned to someone other than the duly appointed PDJ upon remand. That judge has been pretty patient with him, in my opinion. She seems to be pretty fair, but that's just me. All right, that was the end of that. Okay. All right, guys. That was the second stream of the day. We went a little longer this time. I think it's probably enough for me on a Friday. So, I appreciate everyone being here. And if you could hit the like button for me, it always helps me out a lot. I'm going to take off for now, but I will see you all soon. Okay? Thanks, everybody. Making sure I got everything here. Yep, I think I'm all good. All right, thanks. Bye.